Hello, we are ready to begin part 2 of chapter 7. In part 1 we looked at variation in legal training and variation in prosecution. In this chapter we're going to begin with a look at variation in defense and how defense counsel is carried out in different countries. There are a few systems, but they are few in number, that rely on private individuals to provide defense to the accused, to the defendant. Those include some of the Islamic systems and some of the systems that are based on socialist principles. The example I'll be using here will be China. More typically, however, defense is provided using some kind of governmental supported system or an appointment by a judge of a defense counsel. Under the government supported, assigned counsels are typical in some of the United States, for example, and other countries as well, or there might be some national or state legal assistance program that can be drawn upon to provide defense counsel for defendants. Essentially, in all countries, the defendant has the option of hiring a private attorney. But our concern here is with those people who may not have the financial ability to do so. And that's why we're going to talk about more the government-supported ones, or the use of lay people. Again, in essentially every country, it's possible for you to hire a private counsel to serve for you and represent you in court. But those aren't the ones that we're interested in right now. The use of lay people is still found today, as I mentioned in the earlier slide. Some of the Sharia courts of Saudi Arabia, for example, provide for lay people, family, friends, even the person who's standing trial can come in and speak for you as your defense counsel. The Sharia courts provide an interesting example of this, because Muslims have typically acted for themselves or nominated some of the others' relatives or character witnesses to act for them. So this idea of relying upon lay people in a criminal setting under Islamic law for Muslims themselves is not seen as being a very dramatic difference from what would be expected. It's very consistent with how many other aspects of Muslim life is carried out as well. Those countries that are relying more upon socialist principles, as I said, China would be an example, also will allow lay people to come in and speak for the defendant. And we're going to come back to this a little bit later as we use China as a specific example. Let's turn to the government-supported systems. In most countries, the defense of the accused relies more on legally trained professionals who are serving either as assigned counsel or working for some kind of governmental program. And in this chart you see the examples of Argentina, Brazil, Peru, and Paraguay as just a few that provide for assigned counsel for the individual who is standing trial. The national or state programs, Chile and Mexico, provide some examples of this, where there is a government-sponsored defense attorney kind of system. As many of you know, in the United States, we also have government-supported public defenders and public defender offices in many states. But there are also still states that rely more upon assigned counsel. And that assignment can come as the result of the judge looking down a list of eligible people and assigning the next person on the list to serve as defense counsel. Or it could be, in some cases, private individuals or private law firms have contracted to provide defense for that jurisdiction for a particular period of time. So a variety of ways in which defense counsel can be accomplished. Bring to your attention the note at the bottom of this chart as well, that we need to keep in mind that variation exists even within these countries. For example, Mexico also has an assigned counsel government support system, and some hybrid systems that they're influenced by socialist principles, provide for legally trained defense counsels. We see an example of China a little bit later as that as well. So This is just to kind of give you an idea of what variation exists, and we really can't identify particular countries as falling specifically into one or the other of these systems. The adjudication process is one in which we are referring to the procedures that are used to deciding factual disputes. And when we're talking about criminal cases, those factual disputes are specifically concerned with whether the accused committed a criminal offense. The adjudicators are those individuals responsible for making that determination, deciding those factual disputes. Typical adjudicators are judges, lay judges, or jurors, and we're going to take a look at each of those now. This chart identifies those three groupings. Professional judges, as it notes, typically come to their position in one of two ways. In many countries, they have been selected by others. That selection could either be by appointment or by election. Appointment could be from legislators who appoint the person to be a judge, could be even by other judges serving at maybe a higher level court, appointing judges at a lower level court. Or it could be the citizens of the community who are participating in an election, and they select amongst various candidates those individuals that they would like to serve as their judge for a particular period of time. Election isn't frequently found. The United States jurisdictions certainly include examples of election. Many other countries see the election of judges as being kind of an inappropriate way to choose judges. They think that makes them too willing to abide by public opinion and not willing enough to abide by the rule of law, for example. Self-appointment of professional judges is the other option. Under this one, as it implies, the individual simply decides that they would like to be a judge. And in doing so, they go through the particular process of taking the education, the background, whatever it might be, to become a judge. This is more typically found in the inquisitorial system, where individuals going through or getting their law degree upon graduation kind of made the determination that they would like to be a judge as opposed to a defense counsel or prosecutor and so on. And their academic training would concentrate more on that position of judge, and their apprenticeship would be with the judicial department, so that it's possible that you could have in some of the inquisitorial processes some very young judges, individuals who have simply chosen this as their career track, and don't have any experience at all as either a prosecutor or a defense counsel, which would seem a little bit strange to those of us in the United States, where most of our judges come to that role after having served in some other capacity within the court system, as I say, as a prosecutor or a defense counsel. But self-appointment is possible in many of the jurisdictions. The category of jurors as adjudicator, as deciders of fact, is a modification of earlier systems by which exoneration from accusations was achieved. You'll read in your textbook, and you're familiar from other sources with things like the trial by ordeal, compurgation, or by battle. And in each of those cases, the idea was that you would have individuals, the accused and the accuser, going at each other, for example, to decide where truth would lie. Or you would have community members making decisions based upon a particular ordeal that the accused was set to. The version that came to the American colonies had individual jurors evaluating the testimony of witnesses to determine if the defendant is guilty or not. And this is the system that we're most familiar with now under the adversarial or accusatorial process, where a group of jurors who have been chosen at random from amongst those eligible to serve in this capacity in the community are then set before the court and listen to the evidence as presented by the prosecution and by the defense. And those jurors then will make the decision as to whether or not the charges have been proven by the prosecution or not been proved, and the decision then would be either to find the person guilty as charged or not guilty. Lay judges provide a process that we aren't quite so familiar with in the United States. Here we still have private citizens who are playing a role as adjudicators, but now they're serving as lay judges rather than as jurors. And in this sense, they sit with the professional judges on the bench, and they participate fully in the questioning of witnesses, the determination of which witnesses will be called, and play the role of judge, but they just happen to be lay people rather than trained as judges. This provides an equivalent to the jury trial. It allows citizens to have an input into the adjudicatory process, and it is found most typically in the inquisitorial system. This is an interesting process. We will come, your textbook talks more about it in terms of how Germany uses lay judges, for example, and you'll get an idea of how these are carried out. It also presents an opportunity for an interesting comparison in a term paper for those of you that would be interested in having this as one of your topics for your term paper. As we look at the different ways in which these adjudication types can be carried out, this refers to a chart that's in your textbook as well. We have a continuum by which we could have a heavy reliance simply on the professional judge. Saudi Arabia is an example of that. And at the other extreme of the continuum is a heavy reliance upon lay people, and England provides a good example of that. Falling in the middle, a mixed reliance on both judges and lay people would be Germany and its use of lay judges. Quickly looking at what you see on the screen as well, in Saudi Arabia, the judge or the Qadi follows the Quran and the Sunnah in directing how the various players carry out the adjudication process. The Sharia sees no reason to have lay people involved, since the Qadi is assumed to be unbiased. If he isn't biased, he'll be going to hell. So the Sharia doesn't necessarily rely upon or require any kind of lay people involvement or professional involvement for that matter, and for the defendant. The Qadi should serve that role. On the other hand, lay people are allowed to, as I said earlier, provide testimony, especially to the defendant's character, and speak in favor of the defendant. And much of that is going to be used not so much in determination of whether the person is guilty or not, but rather in terms of what kind of sentence might be handed down by the Qadi. Let me jump to the heavy reliance on lay people before we go to the middle range. Jury panels are chosen at random in England from voter registration lists. That randomness is said by many to be a better example of how random should come about than we find in the United States, because the American process of voir dire is avoided as much as possible. And instead of having cross-examination by defense and prosecution and even the judge, and the use of peremptory challenges and even challenges for cause, under the British example, it's more just the first names chosen are the ones that are placed on the jury panel. Now, the challenge for cause, by the way, I probably shouldn't have used that as an example, because in England you could still easily make a challenge for cause saying that the proposed juror is the son-in-law of the defendant, something like that, and they would be, of course, excused. But it's more the peremptory challenges that you wouldn't find quite so much under the British system. So you would still have jurors, you would still have lay people serving in that capacity, and they would be the ones that would be deciding the issues of fact. That mixed reliance example of Germany goes back to, as I said, the lay judges, which serve as another way to bring lay people into the court process, into the adjudication process. They'll be serving on a mixed bench with professional judges. As it reads there, in the lower court levels in Germany, you would have one professional judge and two lay judges. For the more serious crimes, the upper level courts, you might have three professionals and two lay. The decision for whether the person is guilty or not is made by majority vote. So you can see that in the lower courts, for example, the two lay judges could presumably outvote the professional judge. In some systems, at least one professional judge's vote is required in order to find a person guilty. That varies from country to country that uses the lay judge system. The process by which these lay judges are selected also varies quite a bit. Standard would be to use the voter registration laws, for example. And the lay judges are going to be serving not just for one particular trial, but probably for several trials or for several weeks. And then when their service is over, there's a time period for which they will not be called again. So some similarities with jury system, but also some significant differences. I wanted to also bring to your attention the box on pages 206 and 207, the impact box. I think this is an interesting point that isn't oftentimes made or understood. It regards the concurrent consideration of guilt and sentence, which we find primarily in the inquisitorial system. In the United States, as many of you know, the admissibility of testimony will differ whether you happen to be in the trial phase or the sentencing phase. Much more restrictions, many more restrictions placed upon what testimony, what evidence, for example, is admitted under the trial stage. Under the sentencing phase, you could find out information about the person's prior convictions, other information that might help you in determining the appropriate sentence. But in many other countries, especially again those under the inquisitorial system, the guilt finding and sentencing functions aren't separated. In France, for example, they really don't make any distinction between the two. It's just assumed that when a person is undergoing trial, the determination of guilt and what should happen to the person, what should be an appropriate punishment if they are guilty, is just all part of the same process. Similarly, in Germany, the unified trial includes evidence about the defendant's character, as you're giving evidence about the crime. So the idea that guilt and sentence should be separated is more of a adversarial, maybe more specifically an American distinction than we find in many other countries. Moving quickly to the variation in court organizations, several of these are provided in the remainder of the chapter. Basically, there isn't very much difference among the way countries set up their courts. You have upper, middle, and lower level courts, and that's pretty much true in all the countries. We see some examples here of court organization in France, England, and Wales, and Nigeria. In France, for example, as is highlighted there, we see examples of all cases are going to be going to court, presumably. The accused provides a statement to the court. The attorneys pose questions, usually through the judge, since this would be the inquisitorial system. The court calls witnesses. You can get clarification of relevance. The attorneys can question witnesses, typically through the judge. Closing arguments can be made. Any prior convictions of the accused are admissible, as I was just talking about, as relevant evidence. The guilt finding and sentencing stages are considered concurrently, again, as we were talking about just before. This whole process, then, is one that is very similar. It would not look at all unusual to somebody coming from pretty much any other country in terms of how the proceedings go, unless you were concentrating more on the differences that we find between adversarial and inquisitorial, and not so much on just the role of the court itself. In England and Wales, pretty much all criminal cases begin at the magistrates' courts, and most of them are completed there as well. Minor cases will actually stay at the magistrates' courts. The more serious offenses are passed along to a mid-level court, the trial court or the crown court. Nigeria presents a little bit different kind of situation because we have here the addition of traditional courts. It's possible that in some of those northern Nigerian states where Sharia law has been allowed, that some types of crimes can be heard in traditional courts or customary, which are sometimes called customary courts, and the Sharia courts. This provides a more informal kind of aspect to the court organization than we might see in some of the other countries. China presents a little bit different situation. Here we have an informal system with the People's Mediation Committee, And these courts, in quotations, are not part of the formal system, but it's also where many of the trials begin in an attempt to determine a resolution to the conflict before the formal process even begins. And in fact, many of the cases in China can be handled at this level. When we get into the formal system, however, we have 4 layers, starting with the basic People's Court and moving up all the way to the Supreme People's Court at the top. Saudi Arabia follows a traditional format as well, with trial, appellate, and courts of last resort. Criminal matters beginning at the ordinary court level. The cases are typically heard by a single judge, the Qadi, unless the penalty of death or amputation is possible, in which case a panel of 3 judges will hear the case. So as you can see, there was pretty much similarity amongst the ways in which the courts are organized, just a few little differences by country, but for the most part you're going to have lower level, mid, and upper level courts. That completes Chapter 7. Just some reminders for what you might consider to do for a term paper. You could look, for example, at the variation in how, or even if, defense counsel is provided for indigent defendants amongst various countries. You could look at differences between the jurors and lay judges. For example, people are concerned that lay judges might be overly influenced by the professional judges when making a decision. But by the same token, some people have said that jurors can be particularly susceptible to the oratory skills of prosecutors or defense counsel, and they can be influenced in that manner. Pros and cons of a unified versus a separated or specialized legal profession would be another area that you might want to look at for the term paper. That concludes the PowerPoint presentation for Chapter 7. Thank you for your attention.